Mic check, 1, 2, 1, 2. You want to be in this video?
That's a negative.
Too late. All right, today I'm doing a follow-up on the Katy Perry copyright decision, and you're gonna hear noise in the background because I can't even get into the car to do a car vlog today, but let's do this. I'm gonna break down Adam Neely's analysis of the Katy Perry situation, which is a video he posted about 7 months ago that went quasi-viral. Now, a bunch of people in the comment section of my 2 videos on the Katy Perry situation, if you haven't seen those videos, I'll put them up in a tiny playlist right here. A ton of people in the comment section of those videos were saying, hey, you better watch Adam Neely's analysis of this because you got it wrong and he's got it right. Now, I had watched his video before I made my first video on the subject, and I rewatched it before making my follow-up vlog that was the dismissal of the lawsuit against Katy Perry. Not only did I rewatch his original video, but I watched his follow-up video on the subject, which is the pinnacle of irony. We'll get to that at the end of this video. But right now, I'm going to go through his video, and I'm gonna break it down the way I would break him down if he were an expert and I were the cross-examining lawyer on the stand. I'm gonna lay my cards face up on the table. I don't agree with Adam Neely's analysis. I don't agree with it in law, and I don't agree with it in fact. And although I make jokes about not knowing what an ostinato is, I actually did study classical piano for 16 years. While I am by no means an expert, I do have a certain basic understanding of music. But for now, let's get into the breakdown. And Adam Neely, don't hate me. I'm not doing this because I don't like you. I am just doing this to show you what it would be like to be an expert being cross-examined by me on the stand.
We only hear this ostinato in the verses for Dark Horse, but we hear it throughout A Joyful Noise. It's a descending phrase in staccato quarter notes that starts on the mediant in the key of A minor, the 3rd degree of the scale, and descends down to the tonic. It sounds like this. All
right, now I'm gonna stop it here because I don't actually want to play Katy Perry's ostinato in this video because I don't want this video getting claimed. So I'm not gonna play this portion of Adam Neely's video, but go watch it. It's at roughly the 45-second mark, but Adam Neely plays a very interesting trick right here.
Dark Horse's ostinato sounds suspiciously similar. It's in the key of B flat minor, but it's been transposed here to the key of A minor. Wait, I'm sorry about that. That's actually not the Katy Perry. That's the Adagio from Bach's Violin Sonata in F minor. This is Katy Perry's Dark Horse.
Adam Neely is employing a very interesting trick right here that I like to call misleading by appearance of authority. If you are watching his video, you're watching it with the belief that he is something of a musical authority, and rightly so. And so what Adam Neely does here is he plays you the Joyful Noise ostinato, and then he plays you another ostinato telling you that it's the Katy Perry Dark Horse ostinato. Relying on his appearance of an authority, he is telling his viewers that what he is playing for them is the Dark Horse ostinato when he himself knows that he is not playing the Dark Horse ostinato. But in purporting to be the authority, he sort of influences his viewers into think that what he's saying is true in order to mislead them for the purposes of proving his point. This trick is very subtle and it will work on a lot of people. It didn't work on me, but not because I didn't regard Adam Neely as an expert. It's just because I knew that what I was listening to did not sound like Katy Perry's Dark Horse ostinato. Yes? Mummy is exercising. I need like 10 minutes more quiet. So Adam Neely goes through 4 fake examples before getting into the Katy Perry Dark Horse ostinato. The problem with it is that none of the 4 that he played actually sounded anything like Katy Perry's Dark Horse ostinato or Joyful Noise ostinato. And so setting aside that mental trick of the appearance of authority and one's willingness to agree with authority when they tell them something is a fact even when it's not, as a pure musical thing, none of those ostinatos sounded as similar to the Katy Perry Dark Horse and the Joyful Noise ostinato. The other problem, and Adam Neely sort of admits it later on in the video, is that we have no context for those 4 examples that he played prior to the Dark Horse ostinato. Adam Neely then goes on to frame the question as whether or not Katy Perry's Dark Horse ostinato is it sufficiently similar to Joyful Noise ostinato to qualify as the same piece of music in law.
So the question is this similar enough to Joyful Noise to legally be the same piece of music? The jury seems to have ruled that that is the case.
And again, this is something of a mischaracterization of the actual question at law. The question is not whether or not they are legally speaking the same piece of music. The question is whether or not they are substantially similar such that an ordinary listener would get confused between the 2. And if so, did the person who created the substantially similar piece of work have access to the work that they were inspired from? Now, I am using the term inspired in a tongue-in-cheek way because some people use the term inspired where they should be using copy. And other people allege copying where in fact all they did was nothing more than get inspired by someone else's tune. But the real question in law when it comes to copyright infringement is not whether or not they are legally the same song, but whether or not they are substantially similar such that an ordinary listener would confuse the 2.
All of the analysis and music theory that the plaintiff brought to the table came from one source, their expert witness, musicologist Todd Decker, who is the chair of the music department at Washington University in St. Louis. According to Decker, Dark Horse is at its essence the same composition as Joyful Noise because of a similar synth riff that shares, quote, 5 or 6 points of similarity. Decker is not a sound engineer. He's a musicologist who is trained in 20th century pop, film music, and 18th century European art music.
Decker is not a sound engineer. Okay, why would he need to be a sound engineer in order to be a music expert? What Neely is effectively doing here is sort of pulling a voir dire, which is sort of when you test the credentials of an expert to determine whether or not the court should recognize them as experts. Neely, wearing his hat of an authority, seems to be suggesting that unless Todd Decker, the plaintiff's expert, is a sound engineer, then he is disqualified as being an expert in the file. Or at the very least, the fact that he's not a sound engineer somehow compromises his ability to be recognized as an expert. It's fair game, but I would suggest that one does not need to be a sound engineer in order to be recognized as a music expert in the context of a copyright claim. And Decker's credentials of being trained in 20th century pop music, film music, and 18th century European music, that seems pretty good in order to recognize him as an expert in the context of this lawsuit.
But that doesn't matter though, because you can't copyright tone color. Otherwise somebody could just own the sound of piano. Wait a second, hold up. You can't do that. That's copyrighted.
Nobody was arguing that timbre and timbre alone is a copyrightable element. And so to put forward the argument that Flawe was arguing that timbre and timbre alone was a copyrightable element like the sound of piano is absolute strawman falsifying the argument. And it's a very astute argument technique, because you will recall in the beginning of the video, Adam Neely recognizes that the expert, Todd Decker, recognized 5 or 6 elements that made joyful noise, ostinato, a copyrightable element. It wasn't just one of those 6 elements, it was 5 or 6 distinct elements come together in that ostinato that made it a protectable piece of work. And at this point in the video, he's strawmanning it to suggest or let the viewers think that plaintiff was suggesting that timbre and timbre alone was sufficient for copyright. Nobody would argue that, nobody did argue that, and nobody would buy that argument.
The sound of piano has been copyrighted, so if you want to play that song, you have to use a different sound. All right. Thanks, Todd Decker. Which is unfortunately the implication of this case.
No, it's not the implication of the case. The implication of this case would be that if one put together 5 or 6 distinct elements into one individual creation or one element of a song, that would be protectable. Timbre, rhythm, notes, slide. What were the other elements? My daughter has no idea. Put 5 or 6 building block elements together in an ostinato, and yes, then it can be a protected work. That would be the outcome of this case, not the sound of piano being copyrighted. In every argument, it is essential to be able to identify a strawman argument and call it out hard. Adam Neely,
I'm calling your strawman out.
Despite this, Todd Decker asserted that the descending melodies of both ostinatos are unique. I have not seen another piece that descends in the way that these two do. Interesting. Check this out. This was a short melodic phrase taken from the 1927 tune Old Man River. Granted, this lyric is not a repeating ostinato, and the context is wildly different.
Granted, this lyric is not a repeating ostinato and the context is wildly different, then what good does it do to compare it to that? This is another intellectual sleight of hand, which is presenting a fundamentally flawed argument, but writing off that which makes it fundamentally flawed as incidental. Sure, I've just plucked 4 songs out of a random song, the lyrics are not a repeating ostinato, and the context is wildly different, but it serves as an example for something in this case? No.
It doesn't.
Probably the most closely related ostinato to joyful noise comes from 1984's Moments in Love from the English synth-pop band Art of Noise.
Probably the most similar is a matter of opinion, and that may be Adam Neely's opinion, but I just listened to that. I listened to Dark Horse, and that 1984 ostinato sounds nothing like the Dark Horse ostinato. And the way he says probably the most closely related ostinato when he's coming off an example that in fact was not an ostinato is itself an intellectual trickery. By moving into what he thinks is the most similar ostinato, coming off an example that was not an ostinato, it leaves the impression in your mind that the example he just gave, wildly different circumstances and not a repeating ostinato, was in fact a repeating ostinato. These are very subtle techniques of persuasion, but they are techniques of persuasion nonetheless. These are arguments that I would expect Katy Perry's expert to make. Adam Neely is entitled to his expert opinion, and if I'm cross-examining him, this is how I'm doing it.
But we're getting really hung up on this one synth riff, because in Dark Horse, it's just the background texture for one of the verses. It has the same musical function as a chord progression or a drum groove.
I would respectfully disagree that an ostinato serves the same purpose as a chord progression. It just doesn't. Chord progression is something that is oftentimes unique to certain genres of music, like the 1-4-5-4 in the blues. Ostinatos are limitless sort of themes in a song. They serve a very different... What is that noise? I think the coffee is no longer being heated. Ostinatos are sort of like themes or melodies that play in the background. They are not the baseline chord progression. Nor are ostinatos typical to any one genre of music. So once again, I think it's something of a strawman argument to suggest that ostinatos are tantamount to chord progressions, which are sort of generic to certain genres of music.
Musician and copyright lawyer Charles Cronin recently wrote that until judges recognize and curb this perfidious, or perhaps merely witless, conflating of sound and music by expert musicologists playing to the sympathies of bewildered jurors, we can expect a continuing blitz of meritorious claims like this one, and the deleterious constraints and ambiguities they impose on popular musicians in the American music industry.
So first of all, using a slew of super fancy words doesn't make your point any stronger. And leave it to a lawyer to pretend that they are somehow smarter than the experts in the field.
This is why the lawsuit demanded a trial by jury, because they wanted to confuse non-musician, non-expert.
The term demanded is a figure of speech in all lawsuits where someone demands a trial by jury. It is just legal talk. The way Adam Neely emphasizes the word demanded almost suggests or insinuates that there was some sort of like sinister plot to why the plaintiff demanded a trial by jury. That is just legalese. That is just the everyday way of saying when a plaintiff wants a trial by jury, it simply says trial by jury demanded.
This is why the lawsuit demanded a trial by jury, because they wanted to confuse non-musician, non-expert jurors with fancy music theory jargon that was provided by their expert witness, Mr. Todd Decker.
They wanted to confuse non-musician, non-expert jurors with fancy jargon, sort of like what Adam Neely has been doing throughout his entire analysis.
They share a similar descending melodic arc, starting on the third degree of the minor scale and descending down diatonically by step. Dark Horse ends on the fifth scale degree, the dominant, and Joyful Noise ends on the tonic on its first repetition, although on its second repetition it descends down to what sounds like the sixth degree of the minor scale. However, because of the extreme portamento, the pitch identity is somewhat masked on that final note.
But here it's apparent that Adam Neely sort of doesn't have a full understanding of the legal process itself. Emphasizing the term trial by jury demanded as though it means something is a mistake. And suggesting that the plaintiff wanted a trial by jury so that he could end up with non-musician, non-experts as the jury members is also a mistake. The alternative to a trial by jury is a trial by judge, and chances are he would not have ended up with a musician, musical expert as a judge anyhow. An anecdote that I shared in previous vlogs, but I'll share it again because it's worth sharing. I was once involved in a lawsuit that was a shareholder dispute, oppression remedy relating to an online business. And SEO, that is to say search engine optimization, was a fundamental issue in that lawsuit. We went to trial and we ended up with, I think, an 80-year-old semi-retired family judge who after 30 minutes said that she understood everything about SEO.
Todd, let's take a walk. Listen, man, I know you're just trying to get paid.
An ad hominem attack that is intended to appeal to the emotions of the listeners and not the facts of the argument.
You convinced a jury that the idea of quarter notes descending in a minor scale from the third degree originated in 2008 with Christian rapper Flawe.
Strawman argument. That was not what Todd Decker testified to as an expert. He did not limit his analysis to the elements that Adam Neely just now mentioned. Indeed, he mentioned 5 or 6 elements when, in combination with one another, form an original work. It wasn't just quarter staccato notes descending from a third. It was timbre, it was rhythm, it was sound, it was the entire work composed of all of those individual elements.
Sam, what are you talking about?
I am talking about copyright law.
Like, there's only a certain number of notes that can be recombined in musical compositions, and I think it sets a dangerous precedent to say that somebody can own such a specific piece of our shared musical language. Imagine if somebody or some corporate entity could own a word or a phrase. What kind of corporate capitalist hellscape would that usher in?
Strawman argument. Nobody's talking about owning a word, but a phrase? You mean like just do it? A phrase like I'm loving it? Now, admittedly, there are fundamental differences between trademark and copyright, but this is just to undermine the idea that there is potentially something objectionable in the ability to own a phrase. There is a fundamental legal difference when it comes to copyright between a word and a phrase, and to lump them together in one sentence is yet again a strawman argument. It is a strawman argument to erroneously lead a viewer to believe that somehow words and phrases are legally equivalent. They are not.
Listen, Todd, man, you're helping bring about the musical equivalent of that dystopia with this court case, and you're doing it in a fairly intellectually dishonest manner, because I sincerely doubt you would make the arguments that you made in court at a, academic conference, for example, or you wouldn't write them down in a scholarly article because your academic peers would absolutely eviscerate you for saying some of those things. And yet in front of a jury of your peers, you said them. These are non-experts, these aren't musicians, and they were confused by your jargon. And the precedent that's set by it is kind of dangerous.
Adam Neely, projection is a powerful drug. Watch what you accuse others of, because others can suggest that what you are accusing others of is actually true of you. I would argue that there's absolutely no intellectual difference between testifying as an expert witness in the context of a high-profile case and giving a speech at a conference. On the contrary, I think Todd Decker would take for granted that one would get a lot more publicity than the other. So trying to shame him for his beliefs is not going to undermine the validity of those beliefs. Oh, And you want to know what was the ultimate kick in the teeth for Adam Neely? His video on this subject was claimed by Katy Perry or whoever owned the rights to that song. That was the subject of his follow-up video, that his original analysis actually got claimed by Katy Perry, but it didn't even get claimed by Katy Perry for the portion of the ostinato that was in Dark Horse. Apparently his video analysis was manually claimed, and the portion of the video that they manually claimed was actually the ostinato from Joyful Noise. And so the ultimate irony in all of this is Adam Neely forewarning Todd Decker of the hellscape that he's going to create through his legal opinion. He actually just got bit in the butt by that very same hellscape, and guess who it was that bit his butt?
Katy Perry.
Well, not her, but the people who own that song. That is my analysis of Adam Neely's analysis of Katy Perry's Dark Horse. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. And with all this going on in the world right now, we can really appreciate that these types of problems are totally secondary. But at the very least, it gives you something else to think about, and I hope I have distracted you for at least a little while, and make use of this downtime that you have to develop new muscles, to learn new things, make it productive in as much as possible. Stay safe, stay the course, have faith, and now you know your vlog. Peace out.